Well, we have news of a potential serious legal setback for former President Donald Trump. CBS News has confirmed that his former White House Chief of Staff, Mark Meadows, is cooperating extensively with federal prosecutors investigating efforts to overturn the 2020 presidential election. And his cooperation has Trump allies on edge. Robert Costa explains.
Mark Meadows was by former President Donald Trump's side throughout the aftermath of the 2020 election. Now, sources close to Trump tell CBS News the former chief of staff is cooperating with special counsel Jack Smith in his election interference case. Meadows' lawyers declined to comment about the investigation. But one person close to a key witness says Meadows has provided detailed testimony about his private discussions with Trump. And there is concern he could be moving toward an immunity arrangement with prosecutors.
So, Adam here, and we need to talk. Mark Meadows, Trump's former chief of staff, has become the most devastating witness against him, confirming under oath what documents show about the post-election machinations, while his own book appears to have been an intentional effort to conceal those facts. The testimony provides the most comprehensive inside account federal investigators have ever obtained. This is not a disgruntled ex-employee venting about a bad working relationship. This is not a political opponent making accusations designed to damage a former boss. This is a court-compelled, immunity-protected, privilege-stripped account from the man who was the operational center of gravity inside the Trump White House at the most consequential and the most legally dangerous moments of that presidency. The man who ran the meetings, coordinated the communications, and kept the records of what was happening when the decisions that are now under legal scrutiny were being made. The specific substance of what that account contains is what we're going to walk through in detail because it fundamentally changes the legal landscape surrounding Trump's post-election conduct.
In the special counsel investigation, the New York Times reporting that Trump's former White House Chief of Staff, Mark Meadows, has testified before the grand jury that special counsel Jack Smith has been using in both of his investigations, both into January 6 and also into the possible mishandling of classified documents down at Mar-a-Lago. Now, according to the Times reporting, it's unclear if he has testified in just one of those investigations or in both. But he is arguably the most significant witness that the special counsel could speak to, certainly in the January 6th investigation, but he could potentially also have valuable information in the classified document probe as well. Now, in recent months, folks around former President Trump have expressed some concern, some puzzlement about exactly what was going on with Mark Meadows, because they told us that they didn't have any communication with his legal team. They were unclear what exactly was going on with him. They've even said on our air that there was no communication between Trump's legal team and Meadows' legal team, which raised a lot of questions about whether he was indeed cooperating with investigators.
Here is what you need to understand about why the Meadows situation is so much more significant than the routine story of a former aide cooperating with investigators that political media tends to present it as. Why the specific combination of factors that define his position as a witness makes him categorically different from any other insider who has spoken about Trump's post-election conduct. The significance comes from the specific combination of elements that make Meadows uniquely positioned as a witness and uniquely dangerous as an evidentiary source. First, his access. As chief of staff, Meadows was the operational center of the White House, the person through whom all significant information flowed and all significant decisions were coordinated. He was not a peripheral figure who attended some meetings and heard things secondhand. He was the person running the meetings, handling the communications, and keeping the records of what was happening at every critical moment in the post-election period and during the classified documents period.
He was one of the closest people to Donald Trump, but tonight, close is anything but how anyone would describe former White House Chief of Staff Mark Meadows and his relationships to Mr. Trump. Meadows pleading guilty to federal charges and has been granted immunity by the federal special counsel to testify in the trial against Donald Trump. ABC News breaking the story tonight that he's already talked to special counsel Jack Smith's team at least 3 times this year. Sources say Meadows repeatedly told Trump that his claims of voter fraud in the 2020 election were baseless.
Second, the nature of his testimony. This was not voluntary cooperation from someone who wanted to help investigators. This was court-ordered, privilege-stripped, immunity-protected testimony extracted from someone who had initially tried to use every legal mechanism available to avoid providing it. Courts rejecting privilege claims and ordering testimony means the legal system determined those claims were not legitimate, which itself tells you something about how courts are viewing the underlying conduct being investigated. Third, the documentary record he provided. Texts with lawmakers, texts with media figures, texts with Ginny Thomas, emails and messages mapping the entire operation of the post-election period in real time, written by the people doing the things being investigated at the moment those things were happening. That combination, extraordinary access, court-compelled testimony, and a massive contemporaneous documentary record is what makes the Meadows situation one of the most consequential evidentiary developments in the entire Trump legal saga.
White House Chief of Staff Mark Meadows was at the center of power by former President Trump's side in the hectic final weeks of his presidency.
We were getting ready to win this election. Frankly, we did win this election.
But when Trump claimed victory in the early hours after the election, sources say Meadows told federal prosecutors Trump was being dishonest because the final results were not in. Sources now telling ABC News Meadows secured immunity from special counsel Jack Smith to testify before the grand jury on a promise what Meadows said will not be used against him. The sources say Meadows also disavowed some of what he wrote in his book, that the election was stolen and rigged, and there was actual evidence of fraud right there in plain sight. The sources say Meadows told the special counsel he saw no evidence of fraud that would have changed the outcome. Meadows is now among a growing number of former aides, allies, and attorneys who have agreed to testify in cases against Trump.
The specific framing that makes the headline's language about a cover-up confirmation legally precise rather than just politically dramatic is crucial, because the word cover-up is thrown around in political discourse constantly in a way that strips it of its specific legal meaning. Understanding the specific legal meaning is what makes the Meadows situation genuinely alarming rather than just narratively satisfying for Trump's critics. A cover-up in the legal sense is not just a politician saying things that are not true. It requires a specific set of elements. Knowledge of conduct that would be legally problematic, deliberate steps to conceal that conduct from investigators or the public, and a documented record showing that the concealment was directed or coordinated rather than individual and spontaneous. What Meadows' testimony and documents provide is specifically the material that fills in each of those elements. His testimony that Trump was repeatedly warned the election fraud claims were baseless fills in the knowledge element, showing that the person making the claims was told they were not supported by evidence. His documents showing the coordination of fake electors, DOJ pressure, and January 6th planning fill in the directed conduct element. The January 6th committee's conclusion that his book appeared to be an intentional effort to conceal the facts fills in the concealment element, showing that after the fact, people involved in the events took steps to revise the narrative rather than accurately describe it. That is the legally precise meaning of the cover-up confirmation in the headline. Not a general accusation, but a specific documented testimony-backed account of knowledge, directed conduct, and subsequent concealment that prosecutors need to build a case of that nature. Let's build the full picture of what happened with Mark Meadows and how the judicial orders that strip Trump's privilege claims produced the most comprehensive and most legally credible inside account of the post-election period that federal investigators have ever obtained from anyone with Meadows' level of operational access and contemporaneous documentary record. Start with the privilege battle, because understanding how that battle played out is the key to understanding why the information that came out afterward carries the legal weight it does. Trump's legal strategy from the very beginning of the post-January 6th investigations was built on executive privilege. The theory was that conversations between a president and his senior aides are protected from disclosure because they involve the exercise of executive power, and because forcing disclosure of those communications would chill future presidents from getting candid advice from their staffs. That is a legitimate constitutional doctrine with real legal force and genuine importance in appropriate circumstances. And it exists for good reasons that have nothing to do with Trump specifically. But it is not unlimited, and it has never been unlimited in American constitutional law. When Trump's team tried to apply it as a blanket shield, covering all conversations between Trump and Meadows, regardless of their nature, subject matter, timing, or whether they involve the exercise of official governmental functions, as opposed to private political activity, including conversations that post-dated Trump's presidency and conversations that involved conducting private political activities rather than exercising official executive functions, federal judges refused to accept that expansive interpretation. The court orders rejecting Trump's privilege claims were not close calls or narrow rulings on technical grounds. They were substantive determinations that the privilege claims being advanced were legally overbroad and that forcing Meadows to testify was appropriate. And those determinations matter because they represent official judicial findings that the conversations and documents being sought are not protected, which means anyone who subsequently argues that the underlying conduct was legitimate faces the challenge of explaining why a court determined that the privilege protection was not valid. Now let's talk about what Meadows actually provided when the privilege shields came down and he was sitting before prosecutors without the protection he had tried to use to avoid that moment. The specific content of his testimony and the specific nature of the documents he produced is what transforms the Meadows situation from a legal procedural victory for investigators into a substantive evidentiary breakthrough that changes the contours of the case in ways that matter beyond the immediate proceedings. The most legally significant piece of what Meadows told prosecutors is the testimony about Trump's knowledge of the election fraud claims, and specifically the testimony that directly addresses the sincere belief question that sits at the center of any prosecution of Trump for the post-election events. Meadows told Jack Smith's investigators under immunity that Trump was repeatedly warned that his claims about widespread election fraud were not supported by evidence. Not once. Not in a single briefing that Trump could plausibly have dismissed as a single dissenting view, but repeatedly by multiple people inside his own administration, by advisors who had the specific legal and factual expertise to assess whether the claims being made had any evidentiary foundation, and by people whose assessments Trump would have had every reason to take seriously because they were his own hand-picked team delivering honest assessments of the available evidence. The repeated nature of the warnings is legally critical. A president who hears once that a specific claim may be weak can argue he did not fully process the concern. A president who is warned repeatedly by multiple credible sources with relevant expertise that the claims he is publicly advancing are baseless does not have that argument available. That testimony goes directly to the most critical element of any prosecution of Trump related to the January 6th events. The question of whether he genuinely believed the fraud claims he was advancing, or whether he was knowingly pushing claims he had been told were false. A sincere belief defense, even a mistaken one, is legally different from knowingly advancing false claims. Meadows' testimony, if believed, is the inside account from the person closest to Trump, saying the knowledge was there, the warnings were delivered, and the decision to keep pushing the claims was made in the face of that knowledge. That is the heart of the intent question. And the heart of the intent question came from Trump's own chief of staff. The documentary record Meadows provided alongside his testimony is equally significant to the evidentiary picture, and in some ways more durable and more resistant to legal challenge, because documents do not change their account over time, the way human memory can. And because the contemporaneous nature of these specific records makes them particularly difficult to explain away through alternative characterizations. The texts and messages Meadows handed over to investigators covered multiple critical channels of the post-election operation. Texts with members of Congress discussing the fake elector strategy, the plan to submit alternative slates of electors from states where Trump lost in an attempt to give Vice President Pence an illegal pretext to reject the certified electoral votes. Texts and communications about the pressure campaign on the Department of Justice to open investigations into alleged fraud in specific states, despite DOJ leadership's assessment that no such fraud had affected the outcome. Communications about the events of January 6th itself and the coordination of activities that preceded and accompanied the Capitol breach. And messages with Ginny Thomas, the spouse of a sitting Supreme Court justice, about strategies to overturn the 2020 result, which placed a post-election coordination effort in a network that extended into the judiciary in ways that created its own set of concerning implications for institutional integrity. All of those documents are not just politically revealing. They are contemporaneous records created during the events under investigation by the people conducting those events. They cannot be explained away as faulty memory or mischaracterization by investigators. They are what they are. The record of an operation as it was being run, in the words of the people running it. And then there is the January 6th committee's specific and legally precise conclusion about Meadows' book, because this is the element of the Meadows story that most directly and specifically fills in the cover-up dimension of the headline rather than just the underlying conduct dimension. And it deserves to be understood on its own specific terms, rather than as just another piece of political commentary from an opposition party investigation. The committee concluded, based on their review of the documentary evidence and testimony, that Meadows' memoir appeared to be an intentional effort to conceal the facts and mislead investigators about Trump's knowledge and intent. That is not a committee saying they disagree with the book's conclusions or that it presented events in a favorable light. That is the committee saying the book appeared to be designed to create a false record, to put into the public domain a version of events that contradicted what the contemporaneous documents show was actually happening. That distinction matters enormously because it speaks directly to the concealment element of the cover-up theory. If the contemporaneous documents show one thing and a subsequent book presents a conflicting account that appears designed to obscure what those documents show, that is, textbook post hoc concealment of the kind that prosecutors look for in building obstruction and cover-up cases. And having that conclusion in the official record of a congressional investigation, supported by the specific documents and testimony that the committee reviewed, gives any future investigator a starting point and a roadmap that does not require them to build from scratch. The judicial orders rejecting Trump's executive privilege claims and compelling Meadows' testimony were not procedural technicalities. They were substantive legal determinations that have implications far beyond the Meadows case, and that establish a framework for how courts will handle similar privilege claims in any future proceedings involving Trump's conduct. Here is what you need to understand about why the privilege rulings matter far beyond their immediate and obvious effect of producing Meadows' testimony, and why they create a legal legacy that persists regardless of what happens with any specific case in the current political environment. When a federal judge rejects a privilege claim and orders testimony, the judge is making a specific legal finding that the claim of privilege does not apply to the conversations and documents at issue. That finding is not just a ruling about Meadows, it is a ruling about the legal character of the underlying conversations and conduct. A finding that a conversation between a president and his chief of staff is not protected by executive privilege because it involves private political activity rather than official executive functions is a finding that the activity being discussed was not an exercise of legitimate presidential power, that it falls outside the zone of constitutional protection that privilege exists to protect. And that finding is not just about Meadows. It is about the legal character of the underlying events. It is a judicial determination that the post-election activities being discussed were private political conduct rather than official governmental action. And that determination has direct implications for how those activities will be characterized in any future legal proceeding where the nature of Trump's conduct is at issue. The courts have already decided that Trump cannot hide those conversations behind a privilege shield. They have already decided the conversations are proper subjects of investigation and testimony, and those decisions once made cannot be unmade by the current political environment or by Trump returning to office. The privilege rulings stand, the testimony they produced stands, and the legal framework they established for evaluating Trump's post-election conduct stands alongside them. The specific content of what Meadows provided, testimony that Trump was warned the fraud claims were baseless, documents showing the fake electors' coordination, records of the DOJ pressure campaign, directly addresses the most critical and most contested elements of the legal case against Trump, and does so from the perspective of the person who was most operationally central to the events being described. Let's be specific and precise about why Meadows' inside account is legally and evidentially more significant than essentially any other witness in the entire post-election investigation, and why the specific characteristics of his position produce a category of testimony that prosecutors consider qualitatively different from what any other witness could provide, regardless of how many other people cooperated with Smith's team. The challenge in prosecuting anyone for conduct that involves multiple conversations, multiple participants, and multiple decision points over an extended period of time is establishing what each participant knew and intended at each stage. Testimony from peripheral witnesses, leaked information, and after-the-fact accounts all have limitations. They may be based on incomplete information. They may be colored by the witness's own interests. And they may describe events they heard about rather than events they directly observed. Meadows' testimony does not have those limitations in the same way. He was present, he was central, He coordinated the communications. He handled the information flow. When he tells prosecutors that Trump was repeatedly warned that the fraud claims lacked evidence, that is not secondhand. That is the account of the person who was in the room, who was part of the chain of information, and who watched the decision to keep pushing the claims be made in the face of that information. And when you add his contemporaneous documentary record to that testimony, the texts and messages that captured the coordination as it was happening, you have a combination that prosecutors describe as the gold standard of evidence. A witness who was there saying what happened, supported by documents that were created at the time that independently corroborate what the witness is now saying under oath. What the Meadows evidentiary record means for Trump's long-term legal exposure, and why the current political situation that has paused the federal cases does not neutralize the impact of what Meadows has already put on the record. Here's the honest, complete picture of where the Meadows situation fits in the broader legal landscape around Trump, and why it matters profoundly beyond the current political moment, beyond the pause of federal cases, beyond the sitting president immunity, and beyond the specific political environment that has made it difficult to act on the evidence that has been assembled. The Meadows evidentiary record is one of those legal developments that is genuinely more significant 5 years from now than it is today. Precisely because of how durable the specific elements of it are, and how directly it addresses the questions that will still be live issues when the current protections no longer apply. The federal cases built around the Jack Smith investigations were dropped when Trump returned to office. Not because the evidence was insufficient, not because the legal theories were ultimately flawed, not because a judge or a jury determined that the conduct described did not meet the legal standard for criminal liability. They were dropped specifically, explicitly, and for one reason only, because of the DOJ policy against prosecuting a sitting president. That is the most important sentence in understanding the current status of Trump's legal exposure. The policy is the reason, not the evidence, not the law, the policy. And the policy is temporary. That policy is temporary and condition-specific. It applies while Trump holds office. It will not apply when he leaves. And the evidentiary record that was assembled while those cases were active, including specifically the Meadows testimony, the Meadows documents, and the court findings that strip the privilege shields protecting that material, does not expire when the cases are paused. It sits in government files, preserved, admissible, and available. A future attorney general operating under different political conditions can pick up the Smith investigation's evidence file and find Meadows' privilege-stripped testimony already on record. They can find the contemporaneous documents already produced and cataloged. They can find the court rulings already establishing the legal framework for why those materials are not protected. They do not need to start the investigation from scratch. They start from a record that is already comprehensive, already legally validated, and already documented in ways that the years since the events will only make more difficult for Trump's legal team to counter. Watch for any indication that Meadows' cooperation with investigators extends beyond the specific testimony already publicly reported, because the scope of what he provided to Smith's team during multiple grand jury sessions, described as lengthy and in-depth, may be significantly broader than the portions that have surfaced in public reporting. Those unreported portions may include accounts of conversations and decisions that are even more directly incriminating than what is already on the public record. Watch also for the specific question of whether Meadows' testimony about Trump's knowledge of the fraud claim's weakness is documented in Smith's 137-page report in a way that creates a formal, publicly available account of that testimony that can serve as the foundation for any future investigation. Watch for how the Georgia case against Meadows develops at the state level, since that case continues, regardless of federal sitting president immunity, and since any Georgia proceedings would produce additional sworn testimony and documentary disclosure that builds on what is already in the federal record. And watch for any congressional effort to formalize the Meadows evidentiary record through hearings or reports that create an official legislative record of what his testimony contains. Because that kind of formal legislative documentation of the evidence makes it harder to simply set aside even if political conditions make criminal prosecution difficult. The judge ordered the testimony. The testimony confirmed the cover-up. And that confirmation is now permanently in the record, waiting for the moment when the political conditions catch up with the legal reality. The specific combination of elements that make Meadows so valuable as a witness is precisely what makes his testimony so dangerous for Trump. He was not just present at the meetings where critical decisions were made, he was running those meetings. He was not just aware of the various strategies being deployed to overturn the election, he was coordinating them. He was not just hearing about the pressure campaign on the Justice Department, he was facilitating it. When Meadows says Trump was repeatedly warned that the fraud claims lacked evidence, he is not speculating about what Trump might have heard in some briefing he did not attend. He is describing conversations he was part of, warnings he witnessed being delivered, information he personally helped transmit. And when the documents he produced show coordination of fake electors, pressure on DOJ officials, and planning for January 6th, those documents are not hearsay or secondary accounts. They are the operational records of the effort as it was being conducted. This is why prosecutors were willing to grant Meadows immunity in exchange for his testimony. They understood that the value of what he could provide was so extraordinary that it justified the difficult decision to immunize a witness who had been at the center of the events under investigation. They understood that no other witness could provide the combination of operational access, contemporaneous documentation, and direct knowledge of Trump's state of mind that Meadows possessed. And they understood that without Meadows' cooperation, the evidentiary picture would remain incomplete in ways that would make prosecution significantly more difficult. The fact that Meadows ultimately cooperated, despite his initial efforts to avoid testifying, tells you something about the strength of the legal pressure he was facing. The fact that he provided the scope of testimony and documents that he did tells you something about what the evidence showed and about the conclusions that prosecutors drew from that evidence. And the fact that courts repeatedly rejected Trump's privilege claims in Meadows' case tells you something about how the judiciary views the underlying conduct. The January 6th committee's conclusion that Meadows' book appeared to be an intentional effort to conceal the facts is not just a footnote in the impeachment report. It is a formal finding by a congressional committee that the person who was closest to Trump during the post-election period made a deliberate effort to mislead investigators about what Trump knew and did. That finding is supported by the documentary record and the testimony that the committee reviewed, including the documents Meadows had already produced. And it is now part of the official historical record of what happened, available to future investigators and prosecutors who may revisit these questions when the current political obstacles to prosecution no longer apply. The Meadows situation is a textbook example of how the legal system can slowly but methodically build a case against even the most powerful figures when the evidence is strong enough and the witnesses are compelled to testify. It is a reminder that executive privilege, while a legitimate constitutional doctrine, is not a blanket shield that can protect any conversation a president wants to keep secret. And it is a demonstration that when courts reject privilege claims and compel testimony, the resulting record can be devastating to the people who tried to keep that testimony from being heard. The judge ordered immediate action. Meadows confirmed the cover-up, and that confirmation is now a permanent part of the legal landscape, sitting in government files, preserved for the moment when the protections that currently shield Trump from prosecution are no longer in place. The evidence is there, the testimony is there, the documents are there, and the court rulings that strip the privilege claims are there. What happens next depends on political conditions that are currently unfavorable to prosecution, but that will not remain unfavorable forever. The legal reality is permanent. The political conditions are temporary, and when the conditions shift, the evidence will still be there, waiting to be used. Mark Meadows' testimony is just one piece of a growing legal foundation. Other insider witnesses have provided similar accounts under court compulsion, creating permanent exposure for Trump. The next chapter of this story will be built on these documents and testimonies.